Has your case been refused because of medical inadmissibility, or have you received a procedural fairness letter? This video will help guide you through the complex world of medical inadmissibility and how Bellissimo Law Group can help. We will cover the legal process, common challenges, and how to navigate these difficult cases. At Bellissimo Immigration Law Group, we specialize in medical admissibility cases. With decades of experience, we're proud to say that we've helped many families and individuals navigate medical admissibility, and the high-profile cases that have helped shape immigration law in this area, like Hillwitz and Calaco. As a starting off point, an applicant can be inadmissible for 3 reasons. The first is a danger to public health, the second, a danger to public safety, and the third, for causing an excessive demand based on the usage of health or social services. To provide some context, a danger to public health deals with contagious diseases that can spread to others. A good example would be tuberculosis. A danger to public safety typically means a medical condition that can lead to unpredictable or dangerous behavior. An example of this could include a traumatic brain injury or a mental health condition. Excessive demand focuses on treatments required for a medical condition that uses both health and social services. The health and social services that are used are measured against the average Canadian, and with this they use a threshold. The threshold is set at just over $27,000 a year, or in the 5-year period, just over $135,000. Previously, Canada Immigration could consider what your treatment would cost in a 10-year period, but with the law change, now they only look at 5 years. The law changed in March 2022, and the threshold was increased by 3, and certain services were excluded. With this change, this allowed for greater inclusion because the costs of certain medications were no longer over the threshold, and a number of services were excluded from the definition. Some examples were special education services and speech-language therapy. Excessive demand also has another component of consideration, whether or not the treatment you're receiving will affect other Canadians who are already in Canada. They consider whether you receiving the treatment will put out another Canadian. For example, if you need to receive dialysis, or if you're going to receive a kidney in order for a transplant. They consider whether you receiving the treatment will put out another Canadian. How do you get here? Well, most applicants have to undergo an immigration medical examination. Once that medical examination is done, you'll either receive a grade A, which means no concerns, or grade B, which has abnormal findings. If you receive a grade B on your medical examination, an immigration medical officer will assess, and if they feel that your condition will cause an excessive demand, you'll be issued the procedural fairness letter. If you receive a procedural fairness letter, you're usually given 60 days to respond, which may seem like a lot of time, but it's not uncommon to ask for additional time in order to gather all the necessary medical evidence you need. If you receive a procedural fairness letter, it's critical to respond with a well-managed mitigation plan. We can help craft these mitigation plans to demonstrate that the impact is less severe, or if perhaps the costs are under the threshold. You're only given the one opportunity to respond, so it's important that you put forth a full and comprehensive mitigation plan because the decision is permanent. We have extensive experience in preparing mitigation plans for Canada Immigration, as well as the Immigration Appeal Division. Like the law we help develop, our approach focuses on an individual's personal circumstances. We also focus on presenting plans to offset costs where possible, and ensuring officers make the decisions they're empowered to make. Medical conditions that often lead to procedural fairness letters or possible refusals are chronic kidney disease, heart disease, most cancers, autoimmune disorders like multiple sclerosis. It's important to act and take steps before your immigrant visa is refused. If you or your family member has a medical condition, contact us to find out how this may or may not affect you. Early intervention can improve the prospects of your case. This is important because if one family member is inadmissible, everyone's inadmissible. Timing is critical to altering the outcome. As well, if there is no way forward, we will be transparent. But don't just take our word for it. Listen to what our clients have to say.